Hi, this is Michelle Zaragoza, team leader for Central Valley, Lodi, Tracy, Stockton, Manteca, Modesto. I believe I got them all. And we are here today with Gov Hutchison. And Gov, we want to say thank you so much for taking the time out of your busy day to actually meet with us. I know it's very difficult for offices to get the attention and your time and earn your time. So I really appreciate you. Being here with us today.
My pleasure. And Michelle, remind me how long you wanted me to go for today, or
About 45 minutes, if that's okay. Or we can go
sure.
longer if people have more questions. I'm good with that too.
And you just sort of want to you want to know what's going on out there in the legal world.
I sure do. I sure do.
All right.
Or they do.
They do. Everybody
Yes.
does. Hi, everybody. Good morning.
Good morning.
I'm in charge of the legal hotline, if you didn't know that. So if you have legal questions, please call. We're there for you. We want to be there and we're ready for you. So as your lawyer, I just want to give you sort of the latest lay of the land legally, what you need to know, what's happening out there. There's some new laws you should know about, some new forms, and some new sort of practices that are going on out there. We're getting a lot of calls on. Number one, before I even get into that, people, of course, ask me, um, COVID, what's changing? Is anything changing? When is it going to change? The answer is right now, nothing has changed, but there's movement towards opening things up. And I think that's going to happen in the next few months. We don't know for sure, but we're meeting with the governor's people. We're pressing them to try to do it. In other words, right now, we're where we've been since last July. You know what that means? That means you still have the PED form, the posted rules of entry, one buying party at a time. The buyer's agent is responsible for wiping down the property between each showing, all showings by appointment, no traditional open houses, everybody wears a mask, nobody touches anything, et cetera, et cetera. This stuff hasn't changed, and it's going to change, but it hasn't changed yet. So we hear about people, oh, I saw an open house going on. Well, they shouldn't be doing an open house. You're not allowed to do open houses. Um,
So what
and
happens if you get caught though, Gov?
well, it depends. I mean, the Department of Real Estate, it's officially against their policy, so they can punish your license. The California Department of Public Health, I mean, it's actually, believe it or not, it's a criminal matter. Most places I talk to, the law enforcement doesn't get involved, but there's some places I talk to where you call the sheriff's office and they'll come out and break up the open house. I've actually run into that. You know what I think the biggest risk is when if you violate these, by the way, if you violate these rules in somebody's house, the sellers often have cameras on. They watch what's going on in their house. And these open houses, same thing. And it's like, imagine if, God forbid, somebody went to an open house that they shouldn't be having, or they go to a showing where the people aren't following the rules and somebody gets sick, COVID positive. They are going to sue. They are going to sue the agent. They're going to sue the property owner. And this is not covered by E&O. This is a serious lawsuit that you don't want to be part of. My advice is you've had to deal with this for about a year now. Please try to deal with it a couple more months, because it's not going to be like this forever. But right now, it's the rules. Right now, we do have to deal with it. Right now, if you don't, there can be consequences. So we will keep you posted. We're pushing. I mean, obviously, we think, and I'm sure you think, that some other types of businesses, like movie theaters or nail salons, depending on where you are in the state, they're starting to open up. I'm in LA and the movie theater down the street just opened up.
Oh my goodness.
So you would think if other businesses can open up, the real estate business should also be able to. And I think but the point is, when your county goes from like purple tier to red tier to orange tier, that doesn't affect real estate. The tiers have nothing to do with real estate. Real estate has its own rules. So our argument is, as these tiers change, the real estate rules should also change, but they haven't changed yet, is my point. And we're pushing in that direction. But whatever you've heard, when is it going to open up? We don't know. Sooner rather than later, but just we don't know. We're pushing for it, and we will see what happens. Okay. Same thing for your offices. You're allowed to open your offices. You just have to make sure that in the offices, people wear masks when people visit your office. Even when no one's there, everyone's got to stay social distancing apart, and it's safer to wear the mask even then. One thing to remember is that there's one new thing. Hopefully it hasn't happened to any of your offices, but if in any work site in California, this is not just real estate offices, any work site in California, if someone who works there, so in the real estate context, it would be someone who works in the real estate office, either an agent or an employee. If anyone in an office tests positive, then who's ever in charge of the office has to notify everybody else who works in the office in writing by the next business day if that person was exposed to the person who's now tested positive during that person's infectious period. So, let's say it happens, someone in one of your offices tests positive, and they tell the broker, the manager, whatever. That person then is responsible to figure out, let's see, their infectious period started 2 days before the positive test. It goes till 10 days after the positive test. Who else was in the office during that time? I have to notify these people in writing. We have a Q&A on our website called California AB 685 notification to employees that'll tell you what you have to put in that written notice. Similarly, let's say in your office, you invite clients in, you invite agents from other offices, you invite vendors into your office. That's okay, you're allowed to do that. They got to wear the mask and everything like that, but you have to keep a record of who comes into your office. Because let's say on Monday, some client comes into your office, wears the mask, everything's good. Then on Thursday, they call you up and say, guess what? Yesterday, Wednesday, I had a positive COVID test. Now you have to figure to yourself, well, if they had the positive test Wednesday, that means when they were here Monday, they might have been infectious. Who else came into the office after that day, after that Monday? Are there any other clients or agents from other offices who came in after that? I got to notify them. You actually have to notify. It's like contact tracing. You're all required to do. Same thing, of course, in your listings. Someone comes in with the PED form, they wear the mask, and then they call you up the next day. Oh, guess what? I just tested positive. You realize, oh my goodness, they were in my listing within the 2 days before that, which means that's during their infectious period, which means I got to notify everyone who came into my listing after they did, which is why you collect the PED forms for everybody. Now, when people come into your office, you don't have to do a PED form. You just have to make a note that they were there. When someone comes into your listing, you actually have to obviously make sure that they submitted a PED form. So all this is burdensome and annoying, but you got to keep doing it for the time being. Okay.
Okay, question.
Yeah.
If we sent an email out to the whole office, because there are people who don't
Right.
follow the procedure because I'm not going to be their mom. I'm over it, right? That go into the office and don't fill out the document and don't do the temperature. So I blanket the email to everybody saying, hey, somebody tested positive on this date, fair warning to all. So that's
Well,
okay. That's in writing. It's not direct.
Remember, we're talking about two different things, though. There's the duty to notify your people who work at your office, and there's your duty to notify visitors.
Right. Which, yeah.
The email is fine for the people that work there because that's a written notification. And of course, you only have to send it to, I mean, if you don't want to try to figure out who was in the office and who wasn't in the office, that's fine. Send it to everybody. That's fine. Just say from this date to this date. You don't have to identify the person who tested positive, but you have to say anyone who was in the office from whatever 2 days before that test was till 10 days after. But look at that Q&A we have, it tell you exactly what to put in that email. I mean, there's
Mhm,
certain things
mhm.
you have to put in
Well,
there.
I just heard that like a lender came in one time, like about a week or two ago, and after we sent an email out, and this lender came in and didn't even bother with it, and I know she knew that this
Didn't
that
bother
an
with what?
individual
Didn't
had
bother with wearing a mask? Didn't bother with
didn't
what?
bother. She didn't even sign in, from my understanding. But I
Yeah,
can't monitor. I'm not everywhere, right? And it's not.
right.
We do have signs everywhere that you have to do this.
Yeah,
You know?
true. I mean, so you're saying no, in other words, you're in charge of all the offices. Each office doesn't have their own sort of whatever person. Is that what you're saying?
Not this particular office.
Yeah,
No, they chose
yeah.
not to.
I mean, you did the best you can. I mean, you tell people there, just because I'm not there doesn't mean you don't have to follow the rules. In other words, when people come in, you have to keep a record, make sure they wear a mask, and ask them if they have any symptoms.
Hmm,
This
hmm.
is all businesses, and we got to do it. And you got to do it for the time being. We don't know how much longer, but things are moving in the right direction. And that's about it for that. All right, we can come back to this. But if you have any questions, just put them in the chat or raise your hand. I'll call on you. What else is going on? Well, there are like three big laws you need to know about. And there's some minor laws and some forms too. The three real big laws that every realtor needs to know about this year. One of them is, for the first time in 15 years, there's a new disclosure form, the Home Fire Hardening Disclosure and Advisory. Did you know for the last 15 years, there basically been 4 disclosure forms and the NHD report? People always say, as a general rule, when I take a listing, what disclosures do I have to do? And I always say, think of it as NHD plus 4. Order an NHD report, and the other 4, transfer disclosure statements, seller property questionnaire, federal lead paint form if it's a pre-78 house, and the 4th one is really 4 booklets. You got to make sure the buyer gets the 4 disclosure booklets. Well, now it's NHD plus 5. There's a 5th form you have to think about every listing you take on residential 1 to 4. It's the Home Fire Hardening Disclosure. What's different about this form is it's not required every sale. It's only required if the property you're listing is in a very high or high fire zone and it was built before 2010. So the TDS is always required, right? Unless it's a probate, REO, bankruptcy. This form is required when a TDS is required, but only if you're in one of these zones and it was built before 2010, which means every single time you take a listing, you got to figure out what type of zone is this property in. And if you live in California, like we all do, there's 4 possibilities. Number 1, you're not in a zone. Number 2, you're in a moderate zone. Number 3, you're in a high fire zone. Number 4, you're in a very high. The form is only required on the last 2. All right, I got a listing. How do I know which zone this property's in? Well, the first thing you do is you look at your NHD report. Your NHD report has 2 fire zones, 2 flood zones, and 2 earthquake zones. So what are the 2 fire zones on the NHD report? There's the very high fire zone. Whoa, that's one of the 2. Yep. If that box is checked, I know I need this form. But then there's another zone on the NHD report. It's called wildland fire area, subject to substantial forest fire risk. If that box is checked, that means you're in a high fire zone or a moderate. Remember I said this new form is only required if you're in a high one. So let's step back for a second. If the NHD report, neither fire zone box is checked, you're not in a fire zone, this new home hardening form not required. If the very high fire zone box is checked, you know this form is required. But what if the very high is not checked, but the wildland fire area subject to substantial forest fire risk is checked? Well, now you know you're in a moderate or a high, but the form is only required if you're in a high. So how do I know if I'm in a moderate or a high? You got to go one more step. The one more step is you have to talk to your NHD rep and say to your NHD rep, which is this property in a moderate or is it in a high? They will know. It's their job to tell you. So you have to ask them. And once they tell you, say, well, yeah, you're only in a moderate. Now, I know some brokerages, they provide the form anytime you're in a moderate or a high. They just do it as a matter of practice. There's nothing wrong with that. There's nothing wrong with that. But it's only actually required if you're in the high or very high. Okay. And even if it's in a high or very high, it's only required if the house is built before 2010. Why is that? Because everything built after 2010 is built under the new fire code, which requires properties built in these zones to have, can't have wood roofs, have to have dual pane windows, can't have combustible fires, landscaping within 5 feet of the home. So they've been built that way. So there's nothing to disclose to the buyer. They're getting a fire safe house. But if you're in a fire zone and the house was built before 2010, it wasn't necessarily built. It might still have a wood roof. It might still have single pane windows. It might still have landscaping within 5 feet of the house. So in those circumstances, you actually have to tell the buyer this. So the form actually has 6 questions for the seller to fill out where they got to disclose if they have a wood roof, single pane windows, landscaping within 5 feet, rain gutters without non-combustible gutter covers, etc. So let's say this various questions they get. The seller says, I don't know what kind of windows I have. Is a judge going to believe you that you really didn't know what kind of windows you had or what kind of roof you have? I think you better figure it out. But the next question is, okay, I got a wood roof. I tell the buyer I got a wood roof. The buyer says, oh, wow, you got a wood roof. I need you to put on a new roof. You do not have to do that. The seller doesn't have to make any changes to their property. All they have to do is disclose to the buyer. They have to answer these 6 questions. And the form basically says to the buyer, hey, you're in a fire zone. You might want to think about fire hardening your house. The seller is telling you if there's any features in the house that are not as fire safe as they could be, and you take it from there. Okay? It's a mandatory disclosure. You have to do it if it's in the zone pre-2010 house. And I think I saw a couple of questions. Yeah, it's right. It's only required on homes built before 2010. Now, confusing thing on this form, if you've looked at it, I just got through telling you it's only required if you're in a high or very high zone. But in section 1, number 3, there's a checkbox. You can check that the home is not in a high or very high zone. You may be thinking to yourself, why is that there? Because I'm not even going to give them the form unless I'm in a high or very high zone. Why is there a checkbox to tell them it's not in the zone? If it's not in the zone, I'm not even going to give them the form. Remember what I said a second ago, though? Some brokerages, just as a matter of practice, actually are giving this form to every buyer, even in a moderate zone, just because they want to. But we recommend, if you want to do that, you should still check the box and tell them that they're not in a high or very high zone. Okay, I personally don't like that, but that's what the law says. The law says it has to say that. And then the last thing that people asked me on this form, at the very bottom, they said, home fire hardening final inspection report. People say, do I have to go out and get a home hardening inspection report? Absolutely not. That only refers to people who have, here's who that refers to. Let's say you had a home built before 2010 and you wanted to do a major remodel. In some places in this state, if you want to do a major remodel on a pre-2010 home in a very high or high fire zone, then you are to get the permit to do that, that local jurisdiction is going to require you to upgrade the fire hardening part also. and they're going to issue you a report that says, yes, you are now in compliance with fire hardening. Only in those rare cases that is when you're going to do this. Now, Teresa's just telling me your broker's requiring it for all properties, even when they're not in any zone at all. I mean, there's nothing wrong with that. But I mean, if you're not even in any zone, I mean, it's not a bad idea. A fire can happen anywhere, right? Why not make the disclosure? I have nothing against it. I'm just saying what's required. Okay. All right. That's one law everybody needs to know about. Here's a second law everyone needs to know about. Prop 19 takes effect Wednesday. What does this mean? This means the ability for property owners to take their property tax with them has been expanded. Current law for the next 2 days is you sell your house if you're over 55 or severely disabled. You can sell your current house, move anywhere you want in the same county where you live now, and buy a cheaper house, and you can transfer the property tax you've been paying on the old one to the new one. For example, you bought a house a long time ago for $100,000. You're paying property tax based on $100,000. It's now worth $600,000. You buy a house in the same county for $550,000. You can take the low property tax basis you've been paying based on $100,000 purchase price, sell that house and move it to the new house you just bought for $550,000, and you can pay the same property tax on the $550,000 house that you've been paying on the house you've had all these years. That's the law right now. That's Prop 60. That's Prop 90. But you have to stay within the same county. You can only do it once, and the new house has to be less expensive than the old house. Starting in 2 days, this has been expanded. Now you can move anywhere in California, and you can even buy a more expensive house and still transfer the property tax on the old house to the new house, and you can do it 3 times. If you're over 55 or severely disabled or the victim of a wildfire. If you're a victim of a wildfire, you don't even need to be 55 or disabled. So this is good news. By the way, there's a slight modification if you buy a more expensive house. Let's say bought the house a long time ago, 100,000, now worth 600. I want to buy one for 650. Sell the 600, sell the first for 600, buy the new one 650. What's my property tax going to be on the 650 house? It's going to be based on the original 100,000 plus 50. The difference between the purchase price of the new one and the sales price of the old one. So your property tax basis on your 650 house is going to be 150, right? Which is a lot better than 650, which it would be without Prop 19. So Prop 19 is a good, if you got any clients or potential clients out there who the reason they're not moving is because they don't want their property tax to go way up. If they're over 55 or disabled or a victim of a wildfire, that shouldn't be stopping them from moving anymore starting tomorrow. And this is only for your primary residence. Now, here's a question. Okay, it takes effect Thursday. But what if I already sold my principal residence back in February, January, last November, right? But I haven't bought the replacement property yet. Even though I want to, buy a more expensive one, or I want to move out of the county. If it's in the county within the same less price, you can do whatever you want. It's been the law for a long time. But let's say I sold my primary residence already last month, 2 months ago, January, last October. I already sold my primary residence, but I haven't bought a replacement yet. And I want to move out of this county, or I want to buy a more expensive house. Can I transfer it after April 1st? If I buy the new one after April 1st, can I still transfer the property tax even though I already sold the old one? We think the answer is yes. We have sponsored legislation to say that definitely you you can transfer your property tax even if you already sold the old one already. We think that our law is going to get passed, but it's not there yet. So as soon as that happens, we'll send an email to every realtor in California saying this is stupid. Right now, I don't know. So if your client asks you, hey, I already sold my principal residence, but I want to buy a new one, or maybe someone's coming from a different county into your county and they want to buy a new property and they're wondering, can they transfer their property tax from the old one? The answer is we think so, but we can't say for sure yet, right? Minerva, good point. Always advise your clients to talk to a tax advisor. But what I'm saying is pretty straightforward. And we have a lot of handouts on our website that under Prop 19, you can just give to your clients to let them read them. So I'm optimistic that it's even going to cover transactions that occurred before April 1st. Or similarly, what if I still have my old house, then I bought a new house and I moved into it, but I haven't sold the old one yet. You can buy the new one first and then sell the old one and still make this transfer. The only question is, can I take advantage of Prop 19 before, if I did one of the two sides prior to April 1st? We think the answer is yes. As soon as we know for sure, you'll get an answer right away. Okay? All right. Third important new law every realtor should know about relates to, unfortunately, evictions. But there's good news and bad news for landlords here. You may have heard on the news today that just this morning, the federal eviction moratorium that's nationwide was extended to July 1st, which means it's not just California where people have problems evicting tenants, it's everywhere. We don't really care in California that the federal eviction moratorium was extended to July 1st because the California one has already been extended to July 1st. But we do care for one reason, which I'll mention in a second. But there's good thing that's happening in California though, and that's called rental assistance. So hang in there, let me explain what's going on. First of all, what about evictions? Can I evict the tenant right now in Lodi or wherever the heck I am? And the answer is it depends on why you're evicting. All right, what if they're not paying the rent? Can I evict a tenant for not paying the rent? The answer is it depends on why they're not paying. If they have a COVID reason they're not paying, you cannot evict them until July. But what if they don't have a COVID reason, you can evict them right now? The courts are finally doing evictions. We are hearing throughout the state, evictions are going forward against tenants who don't have a COVID reason for not paying. Well, how do I know whether my tenant's reason for paying or not paying is COVID or not? The only way to know is to try to evict them. So you got to send them the notice to pay rent or quit, but you don't send them the 3-day notice. You got to send them the COVID 15-day notice, which is form PRQ, pay rent or quit TP for transition period. And by the way, if you try to use the regular 3-day notice, it'll say right on the form, don't use this till July. So the COVID forms are all together on zip form. You can't miss them. So I send the tenant that 15-day COVID form, the COVID pay rent or quit. If they respond in 15 days with the declaration of financial hardship, the form that's attached to the 15-day notice, you can't evict them, but they still have to pay 25% of the rent. What if they submit this form and they don't even pay 25%? You can evict them, but not till July. What if they submit the form and they do pay 25%? You can't even evict them in July. They owe you the additional 75%. Starting in July, you can sue them for the extra 75%, but you can't evict them for not paying the 75%. Now, starting in July, they got to pay the whole rent, whether they are COVID or not, unless it gets extended again, which is altogether possible. All right, but here's the good news. Let's say you're a landlord, or your client's a landlord. You got a tenant who hasn't been paying rent because of COVID for months. They owe you $20,000 in back rent, COVID. They're paying the 25%, but that's it. They owe me 20,000 bucks. Well, starting in July, you can sue them for 20,000. Starting in August, you can sue them in small claims for 20,000. There's no limit on how much you can sue in small claims starting in August for back COVID rent. But guess what? Effective on the 15th of March, a couple weeks ago, 2 weeks ago today, in fact, there's a rental assistance program. If you are a landlord who has a tenant who owes you back rent, you can apply to this program and the government will give you money. The money has been allocated that we taxpayers have paid for. Money has been allocated for landlords to get compensated for back rent from COVID. Well, how do I go about doing this? Well, there's a website, Housing is Key. Go to the website, housingiskey.com. Depending on what county you're in, it'll direct you to how to go about applying. If you're in a county less than 200,000 people, it's administered by the Department of Housing and HCD. If you're in a county with more than 200,000 people, some counties have chosen to administer it themselves. Some are allowing HCD to do it. On this website, you find your county, it'll tell you what to do. So you go to this, you figure it out, then you say, great, where do I get my money? Well, the first problem is you're only eligible to get this money if the income of your tenant is 80% of, less than 80% of the area median income. What does that mean? Every county has a area median income. And on our, we have a Q&A on this called SB 91, Eviction Moratorium Extension and State Rental Assistance. You go to that Q&A, there's a link. It'll take you to your county and it'll tell you in your county, what's 80% of the median income for a household of 3 or something like that. So you'll look on this, you'll say, okay, my county, here's my county, 80% income is this number, three people in the household, there's a number there. If your tenant's income is less than that number, you're entitled to get money. If your tenant income is more than that, you're not entitled to money this go round. How do you know how much your tenant is making? Well, they're going to also fill out an application, and that's one of the things they're going to put on their application under penalty of perjury. What is their income? Of course, a lot of tenants who aren't paying the rent, it's because they've had a reduction in income. So I think there's a pretty good chance if you're a landlord and you have a tenant who hasn't been paying rent because of COVID, they may very well be in that category of their household income is less than 80%, in which case you're eligible, in which case the government's now going to give you money. Here's the other catch though. Let's say the tenant owes you 20,000. The government's going to say, we're going to give you 16,000 if you forgive the other 4,000. They're going to give you 80% of what's owed you if you forgive the other 20%. What if you don't want to forgive anything? You say, I'm not forgiving 1 cent. That tenant owes me all that money. Then the government's not going to give you, here's what the government's going to, they're going to give you 25% to cover the tenant's minimum. They're not going to give you the full, you can now sue the tenant for everything. You don't have to forgive anything. But to get the rental assistance, you're going to have to forgive 20% of what's owed you. That's the choice the landlords are going to have to make. Okay? Assuming you're eligible based on your tenant's income. All this is explained on our Q&A. It's got links to everything you need to know, or just call the legal hotline. We get these calls all day long and we can help you out. Okay? So that's the latest. But let me go back. So right now I'm talking about tenants not paying rent. Minerva, good question. Can landlords increase rent right now? Yes, there are no more restrictions on increasing rent unless you are under California rent control. Well, who's under California rent control? That's apartment buildings over 15 years old. Newer buildings, single family homes, duplexes, you're not under California rent control, you can increase your rent. whatever you want. If your building is under California rent control, you can only increase the rent 5% plus inflation. What's the inflation rate? It varies by county. Call the hotline and we can give you your number for your county. It's on our website also. Usually it's around 1% to 2%. So you usually can increase your rent by like 7%, something like that. But what if I got a newer building or a single family home or a duplex? There's no general restriction on how much you can increase rent, except for this. California law has always said, if your county is under a state of emergency, you're subject to the rent gouging rules, which means you can only increase your rent 10%. Guess what? The entire state of California is currently under a COVID state of emergency. You know what that means? No landlord in California can increase their rent by more than 10% right now, even if it's a single family home. So, single family, duplex, or apartment building newer than 15 years, you can increase your rent 10%. Apartment building older than 15 years, 5 plus inflation. Depends on what county you're in, what the inflation rate is. Okay? All right. But anyway, let's go back a couple. What about the tenant? It's not a question of paying rent, but they're doing other bad things. They criminal activity, creating a nuisance, damaging the property. They're not allowing me to show it. They are they have subtenants I didn't allow. They have pets I didn't allow. Any tenant doing anything else wrong, you can evict them right now. You don't send them the normal 3-day notice to cure a breach of covenant. You send them the COVID 3-day notice to breach of covenant. But you can do this. Now, I know you're in the Central Valley. If any of you guys work over in the Bay Area, there are a couple of places like Berkeley where there are limitations on this. So check there. If you're in LA where I am, you can't evict tenants right now because they won't allow you to show the property because LA tenants don't have to allow you to show it. But if you're not in LA or some Bay Area places, you have an absolute right. The tenant has to allow you to show, and if they don't, that's grounds to evict. Okay? Third, final thing is, what about I'm selling the house? So the tenant, they're paying the rent, that's fine. They're not doing anything bad, but I just want them out because I got to sell a house. Can I evict a tenant right now on the grounds that I need to sell the house? If you're in LA County, no. If you're in a couple of Bay Area places, no. But most places, yes. Central Valley, you can evict a tenant right now just because you want to sell the house. Now, to do this, you have to wait, though, until you have a buyer in contract. You can't say, well, I got a listing on this house. There's a tenant there, so I want to kick the tenant out so I can fix it up and put it on the market and get a buyer. Nope. You can't give the tenant the notice until you actually have a buyer who signs an offer that your seller accepts, and it says on the contract the buyer is going to occupy. Once that happens, now you can give the tenant the 30-day or 60-day notice. And of course, you're not going to give them the normal 30 or 60. You have to give them the COVID 30 or 60, the NTT COVID, notice to terminate tenancy, CTRA. All right. So, but you can evict tenants from single family houses if you sell the house. Even if they're not paying rent because of COVID, you're not evicting them because of that. You're evicting them because you're selling the house and you have a buyer in contract. By the way, there's a couple other ways you can evict a tenant legally now. Number one, if you want to move in yourself, that's grounds to evict a tenant. Assuming the lease is over, you, parent, grandparent, child, grandchild, moving into the house, grounds to evict. But you can't just move in for a week and then move back out and put it on the market, right? You got to move in there for like at least a year. Similarly, you can take it off of the rental market. Patrick, no, the NTT COVID is only authorized if the buyer intends to occupy. If you got an investor buyer, that's not grounds to evict. But you have 3 other reasons to evict. Remember that right now in California, to evict someone for no fault, there's only 4 reasons, and that goes till July. Buyer in contract to live there, owner move in. Third one is you can just take the house off the rental market completely. But that means it's really got to stay off the market for at least 2 years. So you can't use that excuse and then sell it to a buyer who's going to be an investor, because they can't rent it out either for the next 2 years. That's why it's always better to get the buyer who's going to live there. Then you can evict them right now. And if you have some damage to the property and you want to do a rehab, you have to do a rehab to make the house safe. That's grounds to evict too. But if you just want to remodel just because you want to get it ready for sale, that doesn't work. You can't kick the tenant out until you get the buyer in contract. Okay? All right. What else is going on? A few more minutes here. Let's talk a couple more things. Those are the big 3. By the way, there's a form that goes with this too. Landlord, if you have a tenant behind in their rent, you have to, for COVID, you have to give them this new form called the NTRA 2. NTRA 2. To distinguish from the NTRA, what stands for Notice Regarding Tenant Relief Act. If any of you guys were landlords a year ago, you gave this form to your tenants, the NTRA 1. Now it's the NTRA 2. You have to give this form to your tenant right now. If you don't give them the form right now, you may have trouble evicting them in July, and you may have trouble getting the rental assistance, or you may have trouble suing them. So please, if you haven't done it yet, any tenant behind in the rent because of COVID, give them the form. Minerva, yes, theoretically, you could right now give a tenant the notice saying, I'm evicting you because I want to take the house off the rental market. And then you could sell it as long as the buyer understands that they can't, but they can't rent it out, right, for 2 years. So chances are they're going to occupy it anyway, right, if they're not going to rent it out. So you can use that excuse. But I know what you're saying. I don't want to wait till I have a contract. I want to give them the notice now based on taking it off the market. And then as long as I only sell it to a buyer who is not going to rent it out, then I can do that, right? Yeah, you can do that. By the way, what if I sell it to a buyer? What if I evict the tenant because the buyer commits on the purchase contract that they're going to live there? Buyer buys it. They move out a month later. That's going to look bad. The tenant finds out about it. The tenant's going to say they were not acting in good faith when they bought that house and said they're going to live there. And they may be able to sue that buyer for not acting in good faith. And now, because, you know, the only reason I was kicked out is because this buyer signed an offer saying they're going to live there, and they only lived there a month, which means they didn't really mean it when they said they were going to live there. So that's bad faith. Therefore, I'm entitled to a lot of damages from that buyer. So you got to make your buyers understand that as well, okay? This is complicated stuff. I understand that. And if you can avoid it, you always try to tell your clients you need to talk to a California real estate attorney when they ask you questions about. It's not your job to understand all this and explain it to them unless you're getting paid to property manage. I just want you to know it, okay? But anyway, let me wrap up with other things that you want to know about. First, let me talk about 3 quick laws and then a couple other things. 3 new laws other than the big 3 I just mentioned. One interesting, HOAs right now have to allow at least 25% of the owners to rent their unit. Up until this year, an HOA could have said only 10% can rent, only 5%, nobody can rent. HOAs used to be able to prohibit you from renting your unit. Now they have to allow 25%, and they can't arbitrarily say things like, well, you can only rent to family members, or you can only rent to families without children, or blah, blah, blah. They can't restrict who you can rent it to either. They can have some reasonable restrictions. You can't rent to more than 4 people for a 1-bedroom house or something like that. They could say if it's a senior citizen facility, you can only rent to people over 55. You can't rent to someone with a felony record or something like that. They could put restrictions like that, but otherwise they have to let you rent out your property. However, they can prohibit short-term rentals of less than 30 days. So HOAs can prohibit that. Next law is kind of interesting. Foreclosures, there's a foreclosure moratorium, by the way, right now for FHA type loans, VA loans, but other foreclosures are going forward. If you or your client is having trouble paying your mortgage because of COVID, maybe it's because your tenant's not paying you because of COVID, you can apply for forbearance. Your lender has to allow you to not make your payments now and be able to add them on to the end of the mortgage. Plus, starting May 1st, money is coming to California. Money is coming to California to compensate property owners who can't make their mortgage because of COVID. So not only might you be you are entitled to forbearance, but you may actually be entitled to get money. So not just rental assistance, mortgage assistance. We don't know the details until May 1st. We will tell you, okay? Brian, very good question. You've heard, and it was on Fox News, that there is sellers are saying, you close escrow, right? Imagine buying a house, closing escrow, and the seller says, I'm not leaving, and I don't have to leave because of this eviction moratorium. That is not true. I mean, it's true that some sellers are trying to say that, but that seller is not, even if they have COVID, they're not legally entitled because they signed a purchase contract agreeing to vacate the property. That's a contract. Anyone who violates a contract like that can be evicted. The problem that you may have heard about is in some places, the courts, remember the courts were closed for a while? So the courts are still backed up on evictions. So this one case, I really feel bad for these sellers, as I'm sure you do, but the buyers, they closed escrow and the sellers wouldn't leave. The problem is not that the sellers have the right not to leave. The problem is the evictions are backed up in that county. So the buyers are taking a long time to have to get them out. What a nightmare. Can you imagine though, closing escrow and the seller not leaving? They don't have the right to do that. You can evict them. The problem is because of COVID, the courts have been backed up. They don't have the right to stay, but as a practical matter, sometimes it's taking time, which is really bad. But there's nothing you can do about that. The only thing you can do about that is if you think you got a shaky seller like that, you make it a requirement they move out before close. Just put that in the contract. We will not close till 2 days after the seller vacates the property. That's something to think about, right? Okay. What I was going to get at, did you know there's a new law that says if you foreclose on a tenant-occupied property and the person foreclosing doesn't plan to live there, the tenant has 45-day right of first refusal. If they can come up with the money that the winning bidder bid, they get the property, not the bidder. So in other words, imagine you go to an auction, foreclosure auction, you submit the winning bid on a residential property. Now, if you're going to live there, it's your house today. But if you're foreclosing as an investor and there's a tenant there, after the foreclosure sale, that tenant has 45 days to meet your bid. They've got to come up with the money and close the deal in 45 days. If they can do that, though, they get it, not you. It's even worse than that. Even if there's no tenant there, if you foreclose as an investor, anybody in the state of California who wants to own and occupy that property can submit a bid within 15 days after the foreclosure sale. And they got to bid higher than the winning bid. So you wonder, why would they just not go to their initial auction and bid there? Anyway, but whatever, in other words, you won the auction for $500,000. They submit a bid, but you're not going to live there. You're going to rent it out. They submit a bid within 15 days at $530,000. If they can close that and come up with the money in 45 days and they sign an affidavit swearing that they're going to live there, then they get it, not the person who won it. Bottom line is you foreclose today on residential property in California and you're not going to live there, you don't know for 45 days whether you're going to get that property or not. So that's interesting. Things we're seeing out there, are you guys doing multiple offers like everywhere else? We're seeing things like escalation clauses.
Yes.
My offer is 5,000 more than the next best offer you get. Is that legal? It is legal, but here's the risk of doing that. You submit an offer 5,000 over the next best offer. Somebody else offers 500,000 over the fair market value. Your offer is now 5,000 more than that. Seller accepts it, you got to buy it. Yeah, but can I get out of the deal based on contingencies? Yes, you can. But we see people making, in these hot markets, non-contingent offers X% over the next best offer. You could get stuck with being committed to, with no contingencies, to buying something way over fair market value, which means you're not going to buy it, which means you'll lose your deposit. The other risk is, let's say the seller gets two different offers. Each one says the offer is X amount more than the next best offer. If you get more than one, they cancel each other out, and neither one is valid offer, because they would each go up to infinity, and the courts are saying, neither offer is valid at all. So these are the risks you run when you make an offer X amount more than the next best offer. Here's the other thing we're saying. My offer is 10%, 10,000 above the appraised value. Is that a valid contract? First question is, whose appraisal? And second question is, if the house is worth 600, you offer 10,000 above appraised value. The appraisal only comes in at 550 because the appraisals haven't caught up to the comps yet. So now your offer is 560. Does that mean the seller has to reduce their price down to 10% over the appraised value? Yeah, it probably means that. The seller doesn't think it means that, by the way. If a seller knew what they would do, and they would never accept an offer X amount above appraised value, unless it made very clear that they don't have to reduce the price, in any circumstance. Sometimes what people think this means is I'm modifying the appraisal contingency. I'm saying my offer, normally an appraisal contingency is my offer is contingent on the property appraising at the purchase price. And what they really want to say is my offer is contingent, I'll pay the difference if the purchase price is more than the appraisal. But you have to figure out, is that what the buyer really thinks they're doing? What I'm really saying is, if you have a buyer who wants to write something like that, we're saying they really need to talk to a real estate lawyer to help them draft an addendum, making it exactly clear what's going on. And we've had this happen, and these attorneys end up writing these 2-page addendas to cover everything, which is really necessary. So in other words, be careful about a buyer writing an offer like that. Here's the other problem is, yes, Alice, I would definitely put a cap on the purchase price on an escalation clause. Please do that. Absolutely. Patrick, buyer to pay 10 grand more than the appraised value, not to be less than an offer price of 600. Yes, there are ways to do this. There are ways to draft this carefully to make it, just make sure that the way you're drafting it, your buyer really understands that's what it's doing. And if you're on the listing side and you get an offer like that, you sit down with your seller and say, this is what this means, or call the legal hotline and we'll make sure, we'll go over with you and make sure that that's exactly what it means. And so you can explain to your seller, this is exactly what they're saying. They're wanting you to reduce the sales price or something like that. We're just seeing a lot of these things being drafted all over the place and nobody questions it. And you get in a contract and then it falls apart and there's big disputes, right? So those are the two big things we're seeing. We're seeing also things like, if you run into this one, all offers will be presented on Saturday and then it goes pending on Thursday. But wait a second, you said offers are going to be presented Saturday and now you sold it already. Is that legal? Well, the question is, the seller can do whatever they want, right? I mean, the seller can say, yeah, I know I said I was going to wait till Saturday, but I just got this really good offer, so I want to accept it now. I mean, the question is it the seller making that decision or is it the listing agent making that decision because it's their own offer that came in? I mean, you have to do what's best for your seller, and it's hard to convince me, why would a seller not want to wait? Why would it not be in the seller's best interest to wait till Saturday? But maybe one of the offers on Saturday will be better than the one they just took. What's the rush? What's the push? Unless the agent is pushing it, which you hopefully is not happening. Did you know, another thing is, did you know when you submit an offer and you follow up and contact a listing agent, they have to tell you exactly when your offer was presented or when it's going to be presented. They have to tell you that. They have to follow up. They got to tell you, yes, I presented it at 3 o'clock on Thursday, or I'm going to present it at 5 o'clock on Saturday. And then you can follow up again. What happened? Was it presented? They have to tell you. It's an absolute violation if they don't tell you exactly what's going on. They have to keep you informed. What about this? What about you call the listing agent and say, do you have any other offers on this listing? Do they have to answer that question? No. But if they do answer it, they have to give you a complete answer. Here's what I mean by that. And first of all, the listing agent is going to have a conversation with their seller. And that is, if other agents call asking about the status, if we have other offers, should we tell them or not? And let's say you both agree, yeah, we're going to answer the question. If you're going to answer the question, you have to give a complete, you can't just say, yeah, we have other offers. You have to say, we have 6 other offers, and you have to disclose if any of them are represented by your company. We got 6 other offers, and 2 of them are our own buyers. Okay. Then they ask you, how much are these offers that you got? Does the listing agent have to tell you? No. Can they tell you if they want to? Yes. Don't they need the buyer's permission to disclose the terms of their offer to somebody else? No. Unless you're the buyer's agent also. If you're the buyer's agent, if you're a dual agent, yeah, you can't disclose your buyer's offer to anybody else. So if you have both sides, then you're in a dilemma, right? You have the buyer and the seller. There's a pending offer. Then an agent with another buyer calls you up and says, you have any other offers? Yeah, we do. How much is your other offer? And your seller client says, yeah, tell them. And your buyer client says, don't you dare tell them how much my offer is. And your seller client says, yeah, I want you to tell them. Well, which one do you go with? This is one of the dual agency dilemmas with there is no answer to. There's no good answer to that question. Unless you lay the ground rules right up front with your client, like, by the way, seller of mine, if I come up with a buyer, one of my own buyers making an offer, I'm going to tell you right now, I'm not going to tell anybody else the terms of my buyer's offer. If anybody asks, is that okay with you? Because when you get into dual agency, sometimes you have to deal with this. Now, yes, buyers can also prevent this by submitting a confidentiality form that the seller signs agreeing not to disclose the terms of their offer, right? You're right, Patrick. You got to treat everyone the same too. You can't treat certain buyers one way and certain buyers another way. You're going to have certain rules you're going to go by. You got to keep the same rules. Okay, Kyle, let's see. I'm dealing with a situation right now. Offer to pay $5,000 over appraised value, not to exceed purchase price. Appraisal came in way low. Seller is now obligated to sell at that price, right? Yeah, they are. Do you think your seller realizes that? Do you think that seller is going to be happy about that? Do you think that seller is going to try to get out of the deal because they now have to reduce the, I'm just saying, in other words, yeah, that's what it means. And I bet the seller didn't understand that when they accepted that offer. You know what I'm saying? That's why I'm saying be careful about doing it. I mean, yeah, on your buyer's side, you're in good shape. I'm saying good luck with the seller actually going through with that. You know what I'm saying? That's why I'm glad you raised that. It's a good thing to think about. Okay. Let me finish off. By the way, you can ask questions. Keep asking. With a good law that everyone should be happy about, and that is, all of us property owners. If you own your own residence in California, by definition, you have a homestead protection. That's protection against an unsecured creditor being able to use the judgment that they have against you to foreclose on your property. Okay, so what is the homestead protection? Well, prior to this year, your homestead depended on your status. If you were single, it was 75,000. If you were head of a household of at least two people, it was 100,000. If you were over 65, it was 175. And that was true everywhere in California. So let's use me for an example. Last year, me, head of a household, under 65, I had a $100,000 homestead on my house. And let's say I owe my lender another 100,000 on the mortgage. That meant last year, if someone sued me for 200,000, they couldn't put a lien against my property because they didn't have enough money to pay off my homestead and my lien. But last year, if they sued me for 400,000, and got a judgment, they could have foreclosed on my house, paid off my loan, paid me my homestead, and they kept the rest because my homestead plus my secured lien was smaller than the judgment. But my homestead this year has gone from 100,000 to 600,000. Everyone in California, on your residence, your homestead is now either the median sales price of a single family home in your county last year or 600,000, whichever is lower. So since in LA County last year, the median sales price was over 600,000 for a single family home, every property owner in LA County has a homestead now of 600,000, which means someone could sue me right now for 698,000, get a judgment. They couldn't foreclose on my house because their judgment wouldn't be enough to pay me my 600,000 homestead and my secured debt. Okay, so that's a good thing. How much is your homestead? Well, you have to figure out in your county, what was your median sales price last year? If it was over 600, your homestead is 600. If it was between 300 and 600, then your homestead is whatever that number was. And if you're in a county, and believe it or not, there are a couple counties where the median sales price last year was under 300, your homestead is up to 300. Okay, so that's a good thing. Finally, good news. Is this automatic? Yes, this protection is automatic. You do not have to record a homestead declaration to get this protection. However, you should record it anyway. You should go to your county recorder's office and record a declaration of homestead on your house if you haven't already. You know why? Because by recording it, not only are you protected from this creditor putting a lien against your property, if you record it, you can actually sell your house and the lien doesn't even attach to the proceeds as long as you're as long as you buy another house within 6 months. Whereas if you don't record it, if you voluntarily sell, this lien may attach to the proceeds. So that's a good reason to record, especially if you get sued. If you haven't got sued, technically, no big deal. But once you get sued, yeah, it's not too late to record the declaration of homestead. So that's a good thing to know. Okay. Michele, that's about all I've got.
Hey,
I think I got.
a quick question. Will that apply to a mechanic's lien as well?
Unfortunately, no. Mechanics lien, child support lien, tax lien. No, unfortunately, the homestead doesn't protect. It protects you from unsecured judgment creditors.
Okay, is there any other questions, you guys? This is your chance.
And we're going to keep you posted. You're going to keep listening to Michele and pay attention to your emails because we're waiting to hear all sorts of things. When can I do open houses? When are these rules going to change? When am I going to find out whether I can take advantage of Prop 19 even though I already sold my house? On May 1st, how do I apply for mortgage assistance? So things are coming. You guys have been very flexible and adaptable the last 12 months. Keep on being that way for a few more. Eventually, we're going to be, believe it or not, back to normal, whatever that means. But hang in there a little while longer and stay tuned. Keep going to meetings like this. And when you get an email from CAR, read it, because anytime something happens, we send you an email.
Gov, I truly want to appreciate you. You always respond to my emails, and you are actively moving forward and always respectfully meeting with us. So thank you so much. I appreciate it.
Pleasure. And we'll see you again sometime.
Thank you. Yes. All right, you guys, it's Monday. Stay positive and always, always look for the positive in every situation. I'll talk to you guys soon. Bye.
Thank you.
Thank you.